Hello, my name is Craig Altman, founder and president of Tradition Software and Tradition Lien Service, both national companies that serve the U.S. construction marketplace with software solutions and services for document preparation related to construction lien law. Today, I'm going to talk to you about Colorado lien law. Colorado is a great state. I'm old enough to have flown through the old Stapleton International Airport when I was flying east-west from Chicago to San Francisco or San Jose or Sacramento, California. I've played pickup basketball on a business trip at the YMCA in Boulder, Colorado, and then I've also enjoyed a beer just outside Coors Field in downtown Denver while the game's going on. But before I talk to you about Colorado lien law, I have to give you the standard disclaimer here, and that Tradition Software, Tradition Lien Service, and myself makes no warrant, express, or implied for the use of this video, our websites, our software pre-lien to lien, or the documents prepared by Tradition Lien Service. In no event shall Tradition Software, Tradition Lien Service, or myself be liable to anyone for any problem, claim, or loss arising out of the use of our videos, websites, software, or document preparation services. Tradition Software, Tradition Lien Service, and myself are not engaged in practicing law in the state of Colorado, nor does Tradition Software, Tradition Lien Service, or myself provide legal advice in the state of Colorado. Okay, so let's talk a little about Colorado lien law here. And initially, I'm going to, as always, share my screen here. And in doing that, I'm going to show you Tradition Software's website, and within Tradition Software's website here, you can go to the bottom here and state deadlines menu here and select Colorado. And need to refresh this here. Give me a second. Sorry about that. I was on it earlier and I needed to refresh it. And we have a nice one-page recap of the key issues for Colorado on the Tradition Software website related to first notices, lien warning notices, and construction liens. And the same thing too with the Tradition Lien Service website. If I was to go down here to the bottom, I would select Colorado alphabetically, and you can see here we again have information related to Colorado lien law for first notices, lien warning notices, and construction liens. Okay, so initially with Colorado, and I'm strictly going to be talking in this presentation about private commercial, residential, new projects, or current existing residential projects. What much of the country or some parts of the country know as preliminary notices or first notices are not required on projects. But it is a good option for you to consider sending one out at the beginning of the project. It is something that can reinforce to the property owners and also to general contractors, if you're a sub, that you have future lien rights on a project. We can do one for you for as little as $26 through our Tradition Lien Service division, or you can also do construction lien documents, and specifically the Colorado preliminary notice through our pre-lien to lien software solution here. Okay. Now, that being said, what's really important is for everybody, both subcontractors and general contractors in Colorado, is that a lien warning notice is required prior to doing a lien. And you need to do this within 10 days of prior recording a Colorado statement of lien. Okay, so it's absolutely required that you do this. I have an example here I'll show you. And what you're going to want to do is you're going to want to send this by certified mail to the property owner if you're a general contractor, and also if you're a subcontractor. And if you're a sub work with a general, sending it by certified mail to the general contractor is also something you should do. And you're going to get about 25 to 33% of the time success when you're telling somebody, hey, you owe us $17,300 here, and we're going to do a lien claim in Denver County or whatever county the property you worked on is located. If the people, whether it's the owner or the general contractor, doesn't respond to the notice of intent being sent. Okay, so you do want to send it to the owner. You also want to send it by certified mail to the contractor, and you're making an affidavit on the notice itself that you are actually sending it to those parties. And that you also too is going to want, you're going to want that to be also notarized here. That's basically saying that the signatures for the notice are from the person that signed them and not for somebody else. Okay. And then it's always good too to maybe provide the documentation of the certified number here that you sent your notices by. Okay. Now, that being said, let's just say you are not successful in getting the owner or the general contractor to pay you. Then you can then think about then doing a statement of lien in Colorado. And it's basically the same document for either commercial projects or existing residential and new residential. And again, just as a reminder, I'm not talking about anything that is public property based. So if you do something at the Denver Public Library or the University of Colorado in Boulder or wherever, something that's city, county, state authority owned, we're not talking about that kind of situation right now because you cannot put a lien on public property. Okay. Now, the good news in Colorado is that they give you an extra month as compared to many states for you to record your lien statement. But also then keep in mind, as noted earlier, you do need to do the lien warning notice before you do the actual recording of the construction lien. Okay. And an important thing here too is that with the recording of your construction lien, you're going to want to record that warning notice too that you sent out earlier. Okay. And that is something that's very unique to Colorado. So you're going to want to record both the actual lien itself and the previously mailed lien warning notice. Okay. Now, oftentimes you will get paid, but it's not the majority of the time when a lien is recorded. So if you are not paid right away, you do need to think about initiating a foreclosure lawsuit within 6 months of the last day of providing equipment, labor, materials, or services on a project. So if you look at the 4 months deadline for recording the lien, you've only got really 2 additional months to consider hiring an attorney to do a foreclosure lawsuit. Okay. And the actual, lien itself is pretty straightforward. It's a 1-page document here. And you're going to, again, want to get that lien document notarized here. Generally it's going to be about maybe $20 to $30 with a county to record the lien itself. Now, if you are paid on a lien, you definitely then need to release a lien, okay? Because you have recorded a lien against property in NetCloud's title. So the release of the lien should only be done in terms of your check clearing or the payment from the owner or the general contractor clearing the bank here. And Denver County charged $13 for the release of a lien against property that was commercial property that was in, Jefferson County, not Denver County, charged $13 for the release of a lien that was in Jefferson County against a strip mall location that we had worked on. So we would love to work with you at Tradition Software and Tradition Lien Service. Tradition Software, again, has a leased software, do-it-yourself software solution for construction lien management. Tradition Lien Service is a traditional national lien service that works with companies all over the country. You can always reach us at our 800 number, and that 800 number is 800-886-8770. We are based in suburban Chicago, Illinois, in a town called Warrenville in the western suburbs, but we are a national company. We're open from 8 a.m. to 5 p.m. Monday through Friday, and we definitely look forward to working with you and helping you if we can, okay? You have a good day. Thank you.